Ladies and gentlemen, is your family court judge from planet stupid? And how can you judge the judges who are making life-changing decisions regarding your life and your relationship with your children? So, today I am going to help you to understand whether you can have confidence in your family court judge in your child arrangements case, and whether they come from planet common sense or instead are like Judge Dunce here from planet stupid. But before I can start this blockbuster vlog, I simply must run my excellent introduction. I am Philip Kedge, a retired police chief inspector and director of the McKenzie Friend UK network, founder of the national campaign of #LightNotHate and fearless family court vlogger, exposing the madness of the family court in a way that has never been done before. In all my vlogs, my views and opinions are entirely my own. Now, you will have spotted the Shield of Light Not Hate, which means that this is a call to action on how to take a stand against spurious allegations of coercive control and domestic abuse made by vengeful, spiteful, emotionally unhinged and irrationally anxious resident parents, who are mostly mothers, to throw the non-resident parent, who are mostly fathers, under the family court bus to minimise, reduce, restrict and deny contact with their children. So let's crack on. This is about how your judge manages spurious allegations of abuse based on hate at the first hearing dispute resolution appointment or other early direction hearings. Do they have the skills and common sense to identify spurious allegations that amount to nothing more than a total load of bollocks, and to throw them out? Or are they allowing the court to be manipulated by resident parents and their all too often sick in the head family lawyers by simply rubber stamping unnecessary and destructive fact-finding hearings, which themselves pit parents against each other in conflict and acrimony, where children are caught in the middle being unimaginably harmed? Now, it's important to put all this into context. 20% of family court cases don't have any allegations of abuse and really should be resolved at mediation. From what I observe, 20% of cases do have significant issues around domestic abuse and coercive control that we all understand, and of course will need fact findings and appropriate safeguarding measures, which leaves 60% of cases that are centred around mudslinging allegations based on hate, which I believe the family court is totally mismanaging, and it is that 60% which this vlog focuses on. So I have come up with a template of 10 points that I believe will help you to determine whether your judge is from planet common sense or from planet stupid when dealing with spurious allegations of hate at the first hearings or fact-finding case management hearings. Now, I am the McKenzie friend who just keeps on giving. And at the end of this vlog, I will explain how you can download this 10-point template for yourself. And it's up to you. It's not for me to tell you what to do in your case, but perhaps you could take it into the family court, have it in front of you, and tick off the points one by one. How brilliant is that? So, point number 1. Let's take a look. Has your judge read your position statement? As a litigant in person, your concise, well considered and crafted position statement is the foundation for your voice. Always confirm with the judge that they have read it at the start of the hearing. If not, that's not good enough. You should insist that they do. Now, if you need help with your position statement, then please contact me at contactphil.co.uk. Has your judge interrogated Cafcass and the safeguarding letter? In the safeguarding letter, has Cafcass raised concerns of domestic abuse and coercive control? Have they advised that contact between you and your child cannot be recommended at this time? Has your judge just accepted this with a rubber stamp, or have they fully considered and questioned the contents of the letter? Is there a Cafcass officer present at the hearing? Probably not. There may be a duty Cafcass officer if you are at court, but did you know that the actual author of the safeguarding letter is not themselves required to attend first hearings? I think that is totally unacceptable. The author of the safeguarding letter should be present so that their views and opinions at such a critical stage, at the start of proceedings, can be challenged in person. Surely it's time to start demanding that. Has your judge questioned the motivations of the resident parent in making allegations of abuse and coercive control? Where allegations of domestic abuse and coercive control are made, I want to see judges directly challenge, question and probe the resident parent. However, it is appalling to me that this almost never happens. And why not? Because resident parents all too often hide behind their lawyers, and judges simply allow their lawyers to speak on their behalf. How can they probe, question and challenge when parents hide behind these lawyers? This has to change. Has your judge challenged the resident parent as to why contact has been stopped or reduced? Continuing on the same theme, where contact has been stopped or reduced by the resident parent, I want the judge to be scrutinising that action. Why was stopping contact justified? And if it wasn't justified, what is it the judge is going to do about it? But judges don't do this. I rarely see them doing it. Ladies and gentlemen, this has to change. Has your judge challenged the allegations for relevance? If an allegation of abuse has no direct relevance to future contact, it needs to be struck out. 5 years ago, he slammed a door in anger. So what? Have you never displayed anger? Are you such a perfect human being? Unfortunate things happen. I'm not condoning them. Regretful and unsavoury things happen in most relationships. But what the bloody hell has it got to do with child arrangements, now that you have actually separated? So many of the spurious allegations based on mudslinging hate have absolutely no relevance. But judges are not even considering this or probing and questioning the resident parent. They should be challenging the resident parent. Why is this relevant? And if they can't give a coherent or meaningful answer, throw it out. These allegations have no place in the family court. This has to change. Let's move on. Has your judge explored the real issues pertinent to the child's welfare? Wouldn't that be refreshing if your judge could be bothered to do that? At an early stage to determine that the real issues at the heart of the matter are hurt feelings, parental acrimony, and a mistrust of each other compounded by contact being reduced or denied by the resident parent, and that fact findings will achieve very little apart from throwing more fuel on the fire of conflict, causing even more harm to the children caught in the middle. It's time for the family court to totally rethink its approach. Fact finding should be the absolute exception, reserved only to the 20% of cases where safeguarding is of course necessary, due to abhorrent abuse that we all can reasonably understand. Not the real life stresses and strains and the unfortunate regrettable incidents that may occur in the vast majority of relationships that I dare say your family court judge may even be guilty of themselves behind their closed doors. Oh, the hypocrisy of that. Has your judge assessed the most serious allegations and their relevance? So, in applying common sense, judges need to get straight to the most serious allegations. If they aren't relevant to future child arrangements, then all the allegations should be thrown out. Then, the next question should be, is there a pattern of behaviour that amounts to coercive control? If not, then throw it out. And when we talk about coercive control, I don't mean when the irrationally anxious and emotionally unhinged resident parents, who are again mostly mothers, try and string together a whole load of mudslinging bollocks in the hope of trying to make it sound like coercive control. The family court perhaps needs to take a leaf out of the CPS book, where they say the definition of coercive control includes so-called honour-based violence, female genital mutilation and forced marriage. Other examples include isolating a person from their friends and family, depriving them of their basic needs, and monitoring their time. You see, in its truest form, this means on a daily basis regulating their everyday behaviour. Not on one occasion 3 years ago when the mother was questioned why they were late home, which judges from Planet Stupid are considering worthy of fact findings. Unbelievable. In my opinion, it should be similar to the criminal level of seriousness, where real safeguarding considerations are needed and obviously should be applied. Where the perpetrator continually intends to harm, punish or frighten their victim, or where the victim is exploited for their resources or deprived of independence, where they can't escape and their everyday life is regulated. Now that's a far cry from the ups and downs and common unfortunate and regrettable issues within relationships that are being dragged into the family court and mismanaged by family court judges. It's time for change. Has your judge identified whether the behaviour complained about is because of the breakdown of the relationship rather than the cause of the breakdown? I have never, not once, observed a judge ask or probe this question. You see, when the resident parent, the mostly mothers, throw spurious allegations based on hate, many of them are either so historical that they should be determined as irrelevant, or they focus on the period during the breakdown of the relationship. Well, hello. Of course, when relationships break up, it isn't pretty. How often do separating couples embrace in a hug and skip off down the yellow brick road in opposite directions? It really doesn't happen. And after you have stripped out all that unhappiness during the breakup, what have you got left? More than often, very little. So it's time that judges need to get a firm grip on this question. Unless there are serious and extreme examples of domestic abuse during the breakdown, it's time to accept that these parents have now separated. Draw a line on the past and to move forward with sensible and safe handover provisions. Has your judge given a full and reasoned judgment as to their decision in relation to Practice Directions 12J, Relevance, Necessity and Proportionality? Ladies and gentlemen, at the heart of how the family court makes decisions around allegations of domestic abuse and coercive control is Practice Directions 12J. The central considerations are whether, given the allegations, it is relevant, necessary and proportionate to hold a fact-finding hearing. From my observations, in 60% of family court cases, the allegations are nothing more than spurious allegations based on hate. And it's time that the family court got a grip on this issue, as these allegations, in my opinion, certainly don't meet the threshold of relevance, necessity and proportionality, and where judges, from Planet Stupid, are just defaulting to fact findings and in doing so are themselves throwing fuel on the fire, escalating the conflict and acrimony, resulting in the significant harm to the children. It's time that this destructive rubber stamping of fact findings based on total and utter nonsense stops. Has your judge fully considered the progression of contact at the hearing? This last bit is scandalous. Did you know that judges are pretty much powerless at first hearings to progress any contact unless it is by consent of both parties? Fathers making applications to the family court, desperate and frantic to restore child contact, make applications in the belief that a judge will apply common sense and order contact to be reinstated at the first hearing. They are very much mistaken. You see, judges have very limited powers to do that without contested hearings, when evidence can be heard on which to make decisions based on the child welfare checklist. And this is one of the reasons why the family court can be so easily manipulated by vengeful, spiteful resident parents. It is a total scandal, and what you are likely to get is an impotent judge making gestures about how it is hoped that contact will be progressed at an early stage, which the resident parent then ignores, leaving the judge being about as useful as a chocolate fireguard. An utterly pointless figure of little authority, making you question what's the point of having them in the first place? What do they actually do? Well, that's me nearly done. So let's bring this to a conclusion. Is your judge from Planet Stupid? Well, that may be on a sliding scale, and I believe that I have given you a tick box of fair questions and principles that we, as service users, should be expecting from our family court judges, and from which you can make your own assessment. Now, these points haven't just been plucked out of the air. Many of these principles are based on solid foundations, coming from Practice Directions 12J itself, but very importantly, also the guidance sent out to all judges in a memo by the President of the Family Court, Sir Andrew McFarlane. Reading that guidance is so important to your understanding around the madness of the family court. So I have included it as part of the tip box sheet download. So how do you download it all? Well, go to contactphil.co.uk and click on the link that takes you to all of my amazing vlogs, where you will be able to find this vlog and see the download link. Or alternatively, go directly to my vlogs at philsvlogs.co.uk and again find the thumbnail for this vlog, where you will also see the download link for the document. Ladies and gentlemen, the fight back against the broken, inept, incompetent and incomprehensible family court is starting. And the first stage of that is to empower yourself and to stand your ground and for us, the service users, to start holding family court judges to account. That's me done. I hope it's been an eye-opener. Now, if you would like a one-to-one case review with myself on your child arrangements case, or for all of your solutions-based family court needs, please visit contactphil.co.uk. Until next time, stay strong.